in Waterford City.
Thanks, John. Well, there are 6 days left before you, the voters, decide on whether to or how to amend the Constitution, or indeed whether to amend the Constitution. Saturday's referendum proposes the deletion of the current Article 42.5 and the insertion of a new Article 42A, which, among its provisions, confers imprescriptible rights on children, says the best interests of children will be paramount in court cases, and allows for the adoption of children of married parents. But what will this mean for children? What scope is allowed for legislation which might follow, and what impact will it have on existing constitutional rights? Well, to look at this, I'm joined in studio by Justice Minister Alan Shatter, who is advocating a yes vote, and from our Sligo studio by author and columnist John Waters, who's advocating a no vote. We're going to begin by giving each of the speakers about a minute each to lay out their case, starting with the Minister for Justice, Alan Shatter.
After 2 decades of shocking revelations about child physical and sexual abuse and neglect, I believe it's time for real change. A majority yes vote on Saturday next will result in children being given clear constitutional protection by explicit recognition of their rights in our Constitution and all children being recognised as equal. There are 2,000 children in long-term foster care today, many with no prospect of being properly cared for by their biological parents. Our Constitution denies to many of them the opportunity to be adopted. By voting yes, these children will be given a second chance by making adoption a real possibility. This amendment also recognises a child's individual humanity as a person, whilst also importantly respecting family rights. It requires that children be heard and their views ascertained and given due weight, where they are mature enough and capable enough of forming their own views. It ensures that in the resolution of child protection proceedings, in adoption disputes, and in parental court disputes over the upbringing of children, courts must regard the child's best interests as the paramount consideration. And when would the state step in to protect children? The state, under this proposal, would step in only in exceptional cases where parents fail in their duty to their children's safety or welfare. This amendment provides for the state to take such proportionate action as is required by way of child protection, whilst also recognising that for the vast majority of children it is their parents who are the best carers. A yes vote is a vote for today's children and the children of the future. A yes vote affords a real opportunity for everyone outraged and upset by past child protection failures to do something positive to facilitate children at risk being better protected in the future.
Okay, John Waters, over to you. Slightly over the minute, or to about a minute and a half to 2 minutes for yourself.
This amendment really seeks to use hard cases, genuinely abusive cases of children, in which the main factor was, from a public point of view, the failure of the state to intervene appropriately, to essentially usurp the parental rights of all families. And that is effectively what it will mean, because we will find as we go along that the hard cases will continue to happen, the appalling abuses will continue to happen, the lack of intervention will occur again, and but meanwhile, many innocent parents, many innocent families will be traumatised and brutalised as a result of this amendment. The politicians assure us that the wording has certain meanings and gloss over the technicalities within it. But they cannot promise us. This government will be gone within 3 years. They cannot promise us what any future Supreme Court will actually tell us in relation to the meaning of this. There are several issues within this which are used as a fudge, as a kind of camouflage. Adoption is one. Adoption issues can be dealt with by legislation, that's clear. The voice of the child is already happening under the Child Care Act and under the Guardianship of Infants Act. It happens on a routine basis. But what's really the dagger in this, amendment, is in the wording, very deep within it, and it's certain phrases which jump out at you as you actually pay attention. And I ask the people of Ireland not so much to vote no in the first instance, but actually to read the wording and read their constitution, read Article 41, because that is actually going to be disabled by this wording. It requires this new wording. The new wording will say that if parents fail, the state can intervene if parents fail in their duty towards their children to such an extent that the safety or welfare of any of their children is likely to be prejudicially affected. This will mean that so-called experts will be able to speculate as to the likely outcome for children of certain patterns under certain headings which are defined by the state and ideologically prescribed from elsewhere.
Okay.
And just to finish, there are many other aspects in this which I think we need to really pay close attention to. Above all, close attention rather than emotion is what we need in this debate.
Okay, and we hope to get to those issues during this. Can I ask you first of all, Minister, what is this specifically designed to address that isn't covered under the current constitution or in the Child Care Act? What's the state precluded from doing when it recognises risk that this amendment would enable it to do?
Well, let's take that and in doing that respond to what John had to say. John, firstly, is entirely wrong when he says no constitutional change is required in the adoption area. We have in excess of 2,000 children in long-term foster care. For many of these children, there's no reasonable possibility or prospect of them returning to their biological or natural parents. For many of these children, some of those fostering them would like to adopt them. For so many of these children, the security of adoption, the security of actually being truly related to the family that's caring for them is hugely important. The current constitution prevents that. I've heard John saying the contrary on a number of occasions. Indeed, he raised that issue in the TV3 debate. He is completely and utterly wrong in this context. We have had a series of children over the years in long-term foster care who would very much have wished to be adopted by foster parents. We have some children in foster care for whom alternative adoption arrangements would be very beneficial. So that's a very clear and direct issue. Second issue, under the current law, there's no certainty that where issues relating to a child's welfare are being dealt with by the courts, that the voice of the child will be heard. John is right in saying that on occasions the judiciary can in a discretionary way, make inquiries about children's views. This happens in a very haphazard way. It isn't consistent. This gives a constitutional recognition to that. And I suppose the final point to make about change that's fundamentally important is that we will, for the first time, recognise all children as equal in our constitution and ensure that where there are serious child protection issues, whether we're dealing with the courts making decisions or the social services making judgments as to whether some assistance should be provided to support a family, not necessarily to remove children from a family, the overriding principle will be that any action taken must be in the best interest of children, and that the best interest of the children is the paramount consideration. This is not about, as John is very wrongly alleging when he's trying to frighten people, it is not about in any way terrorising parents. It's not about removing children from parents. It's about the state taking proportionate action, intervening to assist parents where they have difficulty, so children remain within their family homes, and children only going into care after a court hearing and a decision as to what is in their best interests.
John Waters, on that point, this issue of proportionality, and the decision of the best interests of the child, the constitutional law professor in Trinity College, Oren Doyle, says the best interest test can only come into operation once the threshold for state intervention has already been passed. What is it that you fear will come about as a result of this, and why do you believe that the state, I suppose, won't act proportionately?
Well, you see, first of all, Colin, the word proportionate is not defined, so we don't know what that will mean. It's a word which can be, meaning will be attached to it and weight will be attached to it culturally at any given time. Therefore,
what's your fear, though?
Well, my fear is that it actually will be that the best interest of the child phrase can be defined subjectively. I mean, it's a phrase that has been around family law for a very long time. It appears in various conventions on these subjects, child's rights and so on. But the problem is that the cutting edge of the process occurs in a family law court or a childcare court, where an expert witness stands in a witness box and is asked a question: what do you think is in the best interest of this child? And at that point it becomes entirely subjective. It becomes a matter of, and in this, under this legislation, under this amendment, the word likely allows it to become speculative and to a degree prophetic. So therefore, I think that we have, and remember, so far these courts occur secretly. So we have no way of checking, the logic and reason and justice of the kind of decisions that are being made. And the great problem I have is that judges, who are not themselves or don't consider themselves experts in childcare or other issues, tend to give inordinate weight to the opinion of an expert, so-called. Now, there are many aspects of the wording which are problematic. I mean, for example, in the UN Convention, the best interest of the child is used, but it's referred to as a primary consideration. Here it shall be the paramount consideration, which in my view will trump other protections in the Constitution vis-à-vis families, and actually withdraw from children the huge dimension of protection which is offered by their relationship within the family and the context which they get there. It doesn't, as the Minister has suggested, copper fasten that. In fact, it goes against that. I think, and in this respect,
we'll just bring in the Minister on that.
In this respect, the wording actually is quite different and the logic of this amendment is quite different to the UN Convention as it stands.
Minister, the framing of it as the rights or the best interest of the child being paramount in this undermines other rights, is John Waters' assertion.
I'm afraid the way John presents this, he's just completely wrong. It seems to me the ultimate logic of what John is saying is that when children are at risk or in need of protection, the courts should make decisions contrary to the best interest of children. Either you think the best interest of children is the paramount and most important consideration, or your view is decisions should be made contrary to the best interests of children. John seems to be advocating that decisions should be made contrary to the best interests of children. Second point I think worth making is John chooses to ignore the fact that the state can only intervene where there's been parental failure, and the intervention can only be proportionate. And he doesn't like the word proportionate. He says he doesn't know what that means. Well, what that effectively means is the state can't arbitrarily intervene in families. He is suggesting, when he's advocating a no vote, that there will be some arbitrary intervention. He's also, I think, slightly addicted to conspiracy theories. He seems to think that there's a whole range of people who are going to conspire against families for some sort of benefit to remove children from them. This is complete and utter nonsense. But what we do know, and what John chooses to ignore, is yes, there have been in the past terrible failures. There have been failures by the state to properly protect children. There's been failures by the church to properly protect children. The manner in which our domestic social services and our legislation has been administered has been coloured by the fact that under our current constitutional law, courts asked to make these decisions don't and can't on occasion regard the best interests of the child as the most important issue. And finally, John seems to not like anyone who's an expert. Of course, there's no question of an individual expert walking into a court and giving evidence and the expert being taken seriously. If there's a really serious issue about a child who's been a victim of sexual abuse, of vicious physical abuse, there's going to be evidence of that. There's going to be medical evidence. There's going to be evidence, if need be, from social workers, psychologists, possibly from family members. And in the end of the day, a judicial decision is made. I agree with John on one issue, by the way, and I'll conclude on this. For many years, it's been my view there needs to be more transparency.
Well, we are going to get on to that.
If you
just bear with us, Minister.
And
John,
we're going to provide for that.
I just want to bring John in to address a number of those points.
Yes,
John Waters, would you like to respond to what the Minister said?
I want to talk about this question of failure, because it's very interesting, because the implication in all of the rhetoric by the government in this is that virtually every case in relation to taking children into care has to do with physical or sexual abuse. Now, it's very hard to get actual hard statistics on this, but I actually have happened to find figures in relation to 1 year, 2004, which, remember, was the height of the Celtic Tiger. And it's very interesting to actually look at about 2,000 children were taken into care in that year. Only 22% of those cases had to do with actual abuse. Sexual abuse, neglect, not defined, physical abuse, etc. The rest were for quite, reasons that most citizens would regard as included in the attrition of a normal life for a citizen or for a family. For example, 23% of cases in that year were related to housing and finance. In other words, inadequacy of housing, inadequate economic resources in a family. Now, this is quite different, that is more than the total for all categories of actually physical, sexual, or abuse or neglect. So, at the height of the Celtic Tiger, this state actually allowed the children, which is, I think, to take a child away from a parent is akin to, I would say, execution, very close. I don't think I would put a cigarette paper between the concept of taking your child away and basically shooting you in the head. And in this state, 23% of the cases were for housing and finance. And if you actually look, I found an advert in a magazine last week, a newspaper, which lists the reason for children going into foster care as including physical or mental health problems, alcohol, substance abuse, learning difficulties, unemployment, poor housing, lack of family support, and separation from country or region. So the government is being deeply disingenuous in telling us only about the grotesque abuse cases that we all know about.
Let me just bring on Justice Mr. Alan Shatter in on that. The UCC law lecturer Conor O'Mahony says that, in conclusion to an article he recently wrote, the real question is whether the government will take seriously the supposed shift to earlier and less intrusive intervention by channeling the necessary resources to family support services, so that families who find themselves in vulnerable circumstances now would be able to avail of mental health supports, family support agency, all of those kind of things. Is that a commitment that is there, or is that a realistic commitment that could be made before this referendum could be recommended?
Well, firstly, let's be absolutely clear. The constitutional proposal isn't a panacea for all the issues that we need to address with regard to families in difficulty and children. But it's absolutely important that people aren't terrorised by what John Waters is saying. John Waters has listed factors relevant to children being taken into care. No one single individual factor, a housing difficulty, relates to children being taken into care. There are some families in enormous difficulties unable to cope, with children very seriously neglected, and in those circumstances, to provide child protection, children do on occasions need to be taken into care, normally foster care. A significant number of children go into temporary foster care. The families are assisted in resolving their difficulties and the children return to their original families. But John made an extraordinary comment. He said to take a child away from parents is the equivalent of execution or shooting them in the head. Well, I have dealt over the years as a legal practitioner with children who have been viciously sexually abused by fathers. I've had cases where children have been beaten, where cigarette butts have been put on their bodies, where they have suffered appalling and dreadful neglect. John seems to regard children not as individual human beings whose life expectancy should be encouraged and who should have a good quality of life. He seems to regard them as possessions.
But before we get into that, I do want to give you an opportunity, Minister, because you wanted to touch on the point about the greater transparency in family law courts, and I know that's something John Waters is interested in as well. Your proposal to have greater transparency in the family law courts as they currently operate with reporting requirements there along the lines of what we currently see in rape and sexual abuse cases. Is there an implicit critique there by you, or an implicit criticism about how family law courts operate by saying there is greater transparency needed?
I think for the best part of 20 years, this isn't actually a new issue for me to raise. I've expressed concerns about the in-camera rule. The in-camera rule is hugely important for people who head into the family courts, be it in childcare cases, custody disputes, or just general family law matters, to protect their privacy and anonymity. It's terribly important that people who need help through family law remedies, or where there is a concern about the welfare of a child, that the courts, because of publicity, don't present a barrier to important assistance being obtained. But there is a balance. And my concern for a long time, and I think John is probably familiar with the fact I've written about this on many occasions, certainly well before I was Minister for Justice. My concern is there is a lack of transparency. The general public don't really see or understand how family law is administered in practice. There are some people, such as John, who are suspicious about the fact the courts are in secret. But also there are concerns that, to the extent that legislators don't see how they operate, and some people are concerned that there can be a lack of uniformity in the way individual judges deal with family cases.
Okay, I just want to bring John Waters on that finally.
We intend very shortly to publish legislation to provide for that transparency. John, by the way, was entirely wrong when he made a bet that during the lifetime of this government that legislation won't be seen. I can guarantee to John it'll be seen in the coming weeks.
I just want to bring John Waters in on that. John Waters, the opening up of family law courts for greater scrutiny, does that not offer greater insight and perhaps a shift in the culture as to how people view the conduct of family law cases? That transparency in itself will ride shotgun on the actions of state agencies at their worst excesses, as you seem to be outlining.
Indeed. Let me just one brief comment before I go there.
Well, I'm afraid we don't have time for a brief comment. Just on that point.
Okay, I just want to say it is illegal to put out cigarette butts on your children's flesh. Now, secondly, yes, I applaud if this is going ahead. I am not going to be churlish about it, because I have called for this for nearly 20 years. This is vital in any democracy. Transparency and visibility vis-a-vis justice procedures is essential. And I believe that many of the defects that I see have written about for many years in the family law system will actually be eliminated overnight by the opening up of the court. So I'm not in any way, and I congratulate the Minister. And in fact, far be it from, the Minister thinks I'm wrong about everything, but I hope he doesn't think I'm wrong in saying that I believe him to be an excellent Minister and somebody who has a great track record in these areas. For example, 2 years ago,
John, I'm afraid
he exposed the HSE and revealed the secret, the underbelly of the state's care of children in opposition. But what I find extraordinary is that in government he's getting behind the same institutions and people whom he condemned and excoriated.
What we're doing, John, is reforming those institutions.
I'm afraid
and this is part of the reforming measures being implemented.
And to Minister Alan Shatter here in studio, thanks for joining us. We're going to have a look at the US election.